The court is ready to hear argument in 19877, In re Alfred Dewayne Brown, a petition for writ of mandamus from Harris County and the Court of Appeals down there.
May it please the court, Mr. Jefferson will present argument for relator. Relator has reserved 5 minutes for rebuttal.
Mr. Chief Justice, and may it please the court, the Tim Cole Act is the only statute in Texas that confines the comptroller discretion to a purely ministerial role. And by using that language, the legislature emphasized the comptroller's absolute lack of discretion or judgment. The comptroller's only job is to make sure that the verified copies he receives comply with the statute's requirements. Here, no one disputes that they do, and that should have been the end of the inquiry. Mr. Brown served 12 years in prison, 9 of them on death row for a murder he did not commit. After being declared actually innocent by a court of law, Brown sought the remedy the legislature promised him. After extensive litigation over its power to amend its dismissal order, the district court concluded it had jurisdiction to declare Brown actually innocent. Yet the comptroller believes he has the authority to overrule that conclusion. There is no basis for that assertion. It violates separation of powers. It offends a textualist interpretation of the statute. The legislature left that determination quite correctly to the judiciary.
Mr. Jefferson,
yes.
Is there any legal analysis that you think properly fits within the comptroller's ministerial role? And if so, could he have inquired into the jurisdiction under the theory that he was conducting legal analysis?
Well, there can be legal analysis in cases, for example, where the question is, did habeas relief actually declare actual innocence? Or which claim, the Schlup claim or Herrera type claim is valid? Because that is part of the statute. Actual innocence is part of what he is looking at. But jurisdiction is not. The legislature structured the Tim Cole Act so that the judiciary would make necessary rulings like jurisdiction in court. And the comptroller would decide whether the requisite paperwork had been submitted. And that comports with separation of powers. Each branch stays in its own lane. And I think the Allen court from 2012, I think is an answer to your question. The court there said whether compensation may be awarded under the Tim Cole Act depends in the first instance on determinations in the criminal courts of the merits of the applicant's conviction. And then this is the vital sentence. The judgments of the criminal courts are taken as established for our purpose, and we thereafter apply the law component of the Tim Cole Act. So I think that's how you have to look at this. And you have to remember, this was a case where jurisdiction was contested. When the proposal was made for the court to amend its order to apply the special prosecutor's finding of actual innocence, the Houston Union opposed it as an amicus. And there was a briefing by the union, by Rodney Ellis, by Mr. Brown, in which that very question was put to the court. The court had 2 hearings to evaluate whether it had jurisdiction. And then finally it determined, yes, I do have jurisdiction to amend this order to show actual innocence. So that's a judicial declaration. No one appealed it, even though the state was a party. The state didn't appeal it. Of course, Mr. Brown didn't appeal it. It became final. What Mr. Hager is doing here amounts to a collateral attack in which he says he has the authority to override all of that litigation about this very question. And even if it hadn't been litigated as it was, the court, any court, before it signs an order, must establish its own jurisdiction. But because it was litigated, it is very clear that that determination was made. The court said in Thomas v. Long, if there is litigation on the question of jurisdiction, and the court nevertheless goes to the merits without declaring it has jurisdiction, it is implicit in the finding, in the court's merits determination, that it determined it had jurisdiction. And that was
Counsel,
true here.
I understand your argument that it doesn't matter whether the district court was correct, that it had jurisdiction. But help me understand the argument that it was correct. I mean, how could the district court have had jurisdiction to reopen a case like this, years later?
So I think one thing that we should do is go to the statute and look and see whether the statute removes the district court's power to make a declaration like this. If you look at 103.001A, C, a person is entitled to compensation if, and I'm going down to C, the person has been granted relief in accordance with the writ of habeas corpus and the state district court in which the charge against the person was pending has entered an order dismissing the charge, and that order was based on a motion that in which the state's attorney agreed that the person was actually innocent. That's all that the statute says. So that confers jurisdiction on the court in which the charges were pending to make a determination about actual innocence. And yes, Justice Guzman.
Does your reading of the statute, though, mean that the courts have sort of this perpetual jurisdiction to open cases, and that could be problematic, irrespective of the fact that it's not here?
Yes, Your Honor, it could be problematic, but the statute takes care of that as well. The statute doesn't give district courts roaming authority to reopen cases. The district attorney has to move to dismiss. So this is a common theme, unfortunately, in Texas especially. And we see it usually in the DNA context. Somebody is convicted based on based on witness testimony. And years later, sometimes a decade later, the court determines that the DNA actually exonerates this person. And the court can't just reach out and say, oh, you're exonerated, I'm going to issue an order. The court has to have the motion from the district attorney. Look at the Tim Cole Act. Tim Cole himself died in prison and wasn't found innocent until years later. That's the whole basis of the Tim Cole Act, is that the justice system needs to be able to correct these errors that deprive people of their liberty for decades. And we know that this is okay, in part because it's what the comptroller has done time and again. In the Overton case, and I'm sure the court is familiar, that Overton and Rodriguez both were in the same situation as Mr. Brown. Both submitted amended orders years after, some months or years in some cases, after the initial dismissal order. And in those cases, the comptroller looked at the face of the documents and said, these comply. And so he is eligible for compensation. He's eligible because he's entitled under the Act of Compensation.
So
and that's why,
Mr. Jefferson, yes. So when you look at Garcia versus Dial, which does seem to stand for this principle that the court loses jurisdiction, but when you look at that carefully, it's within the context of the state pursuing further criminal proceedings against the defendant. So your argument that it's limited to that would be what you have been arguing, or do you have other arguments to support that limiting function or that limiting aspect of this case?
So I think the first part of your question is right. I think it's limited to that. And it makes sense because the Tim Cole Act is meant as a compassionate way to remove or at least to compensate somebody for a wrongful conviction. But I would also say that Garcia is not the end of the precedent on this question. In fact, in the comptroller's own letter, or maybe it was General Paxton's, they acknowledged that Curry versus Wilson overtakes Garcia. In Curry versus Wilson, that's a 1993 Court of Criminal Appeals opinion. The Court of Criminal Appeals, and I'm quoting here, says, the attachment of jurisdiction conveys upon a court the power to determine all essential questions and to do any and all things with reference thereto authorized by the Constitution and statutes. And they continue to have that jurisdiction until, quote, until all of the issues which arise as a result of the initial action have been resolved. That was a case that really is an exception to the first part of your question, because there the state wanted to get more from somebody who was acquitted. They wanted to get that acquitted defendant to pay fees, the attorney's fees. He had initially been given counsel, and it was later determined that he was able to pay. And that new proceeding came years after, or months after the acquittal, well beyond the time of the trial court's plenary jurisdiction. So yes, I think you're right. Yes, I'm sorry, Justice Guzman.
That's okay. Sorry, Mr. Jefferson. The comptroller distinguishes Curry on the grounds that the relevant statute imposed an express non-discretionary duty on the courts. What is your response to their attempt to distinguish Curry?
So I think I would go back to the statute in our case, in that it directs the court in which the criminal charges were pending to grant dismissal based on actual innocence when the requisites are established and when the court makes that determination. So there's no withdrawal of jurisdiction in that case. And I don't think there has to be an express grant. I think the statute itself gives the court that authority. I also think that the state of Texas is precluded from attacking this judgment. The legislature has decided that the judgment against the state in the criminal case binds the state of Texas, including the comptroller. And I'd point the court to the Engelman case. I really think Engelman is a seminal case in this court's jurisprudence, following on Dubai and other cases that look at res judicata in a jurisdictional context. Engelman holds that when a court has rendered a judgment in a contested action, the judgment precludes the parties from litigating the question of the court's subject matter jurisdiction in subsequent litigation. So the dismissal order here was requested by and is issued against the state of Texas. The district attorney represents the state in all criminal proceedings. The prosecuting attorney's primary duty, though, is not to convict, but to see that justice is done. So here, the Tim Cole Act provision that a person is entitled to compensation once the criminal courts have made the requisite determinations necessarily means that the legislature has concluded that the judgment against the state's attorney would bind the state as a whole, including the comptroller. And again, the Allen case, I think.
We decided a case last term called Ex parte EH. It was an expunction case, and the statute there asked whether there was a court order, and the court said that you can't just look to whether there was a court order. You also need to look to whether the court order was void, because if it was void, it can't have any future legal effect. And I'm wondering why that same principle wouldn't apply here if the dismissal, why wouldn't you have to consider under that same reasoning whether the dismissal order is void for lack of jurisdiction in order to know whether it can have any future legal effect, such as the giving rise to the entitlement to compensation?
Yes, Justice Black, I think that's an excellent question. And I did take a look at that case in preparation for this argument. I think the question is really better framed, not as whether the order is void. The question to me is better framed as who decides whether the order is void. The trial court here determined over a jurisdictional challenge that it had the power to amend the order. And that judgment was never appealed. It's final. The comptroller doesn't have the power to overrule that final conclusion. I haven't said as much as I did in the brief, the phrase purely ministerial, but what that says is the comptroller doesn't have the right to go behind the judgment and decide whether the trial court got it right or wrong. Instead, the comptroller is charged only with assessing facial compliance, checking the documents against the statutory requirements. And this order meets every one of those requirements. And the legislature determined that an order that meets those requirements provides an entitlement to compensation. Those two parts of the statute, the first part is entitlement. We know that Mr. Brown is entitled. The second is just procedural. You don't see the comptroller's name in the entitlement section. You see him in the purely ministerial act of processing an application of exoneration. And Mr. Chief Justice, I see that my time has expired.
Any other questions? Thank you, Mr. Jefferson. We'll hear from the state.
May it please the court, Mr. Hawkins will present argument for the real party in interest.
Mr. Chief Justice, and may it please the court. The comptroller properly denied Brown's application because the face of that application failed to clearly indicate that Brown was entitled to compensation under the Tim Cole Act. I'll start with the text of the statute, then address the trial court's jurisdiction to redismiss a case that it had already dismissed. The Tim Cole Act includes a very specific textual requirement that I don't believe I heard Mr. Jefferson address at all. Section 103.051B1 provides that it has to be clear from the face of the application that the applicant is eligible. The legislature chose these words very carefully. Clearly indicate on their face. Here, Brown submitted two documents that on their face created serious doubt as to whether Brown was entitled to relief. These documents are at pages 673 and 864 of the mandamus record. The document at 673 is the state's amended motion to dismiss. It acknowledges two crucial points. Number one, the state had already moved to dismiss. And number two, the trial court had granted that motion to dismiss.
Mr. Hawkins, on that point, though, I get your textual argument, but on the jurisdictional point, no one appealed the trial court's judgment. So you have the comptroller acting like an appellate judge in determining, whether there was jurisdiction in the trial court. Is that, how would you describe the comptroller's role? Legal analysis that's reviewing a finding that was never appealed?
So Justice Guzman, the comptroller has a ministerial duty to grant or deny the application based on whether the claimant has clearly established entitlement to relief. Here, the comptroller executed that ministerial duty correctly because when he recognized the red flag on the face of Brown's application, he denied relief or compensation accordingly.
Is
Now,
he acting as an appellate judge in making the determinations on the jurisdictional question?
No, Justice Guzman. I think he was doing the same thing that this court indicated that he could do in cases like Allen and Smith and Phillips. That is, make legal determinations as needed to determine eligibility. The Allen case gave no indication at all that the comptroller wasn't allowed to inquire into whether the claim of actual innocence presented there is the same as the actual innocence that the statute is talking about. What Allen is about is really how do you answer that legal question? There's no indication that the comptroller can't ask that question in the first place. Now, when the comptroller saw the document at 864, acknowledging the dismissal and purporting to redismiss the case, he properly recognized that that's a red flag and denied the application.
Hawkins, isn't that only a red flag if you go and look at the law of jurisdiction, which is outside the face of the documents?
Well, Your Honor, I think that that's encompassed within the text of the statute. When the statute says that the comptroller has to determine eligibility based on a court order, necessarily implied in that, and I think Justice Blacklock picked up on this and is exactly correct, it's baked into that concept that it has to be a valid court order issued from a court of competent jurisdiction. To hold otherwise would open the door to multiple absurd outcomes. And let me provide a couple of examples.
Let me ask you this before you do that. Governor Perry, in his brief, amicus brief, argues that the TCA, textually, the TCA leaves to the courts the power to declare actual innocence, including determinations about their own jurisdiction. I don't think, do you think an executive official textually can override, the court's declaration, as Governor Perry so ably argues in his brief?
Well, Justice Guzman, if the court had actually made a finding as to its jurisdiction, and if perhaps the Court of Criminal Appeals had backed that up, I think this would be a very different case. But the actual order at page 864 says nothing about jurisdiction. Now, Mr. Jefferson made much of the fact that there was an amicus brief in the trial court proceedings alerting the court to the jurisdictional defect. But we don't have any evidence that the trial court indicated that. And most importantly, that wasn't before the comptroller. What was before the comptroller is a court order that on its face had a glaring jurisdictional defect. Now, to hold, as Mr. Brown is asking, that the comptroller had a duty to put blinders on and just ignore that defect would open the door to absurd examples. I'll provide two examples.
Before you go there, Mr. Hawkins, you say a glaring jurisdictional defect, but a convicting court has in certain circumstances the ability to address collateral consequences of a criminal conviction. So why doesn't the Tim Cole Act confer jurisdiction on the convicting court to determine this collateral consequence at a time when it then has the underlying factual basis to make that determination?
Because Justice Bland, the Tim Cole Act lacks the type of language that the CCA has said is necessary to invoke that collateral duty exception. And the crucial case, of course, is Curry versus Wilson. Mr. Jefferson alluded to that case, but he did not discuss the crucial language on page 42 of the CCA's opinion in that case. It quotes the statute at issue there, which is Article 26.05E of the Code of Criminal Procedure, which says, quote, "The court shall order the defendant to pay the amount." The word "shall" there is crucial, Justice Bland. That is what triggers the collateral duty exception. And again, it's worth stressing, Curry is an exception to the general rule that Garcia versus Dial sets out. Now here, nothing in paragraph C of the Tim Cole Act imposes any duty on a trial court to do anything. Paragraph C.
Mr. Hawkins, why does that matter for purposes of jurisdiction? Why should there be a difference between must and may? The C says that the court has entered an order. Obviously, well, and arguably it has to if the parts of Romanet 2 are met, but also it says the state district court in which the charge against the person was pending, not is pending. So doesn't that suggest that the legislature is expressly contemplating that the court can entertain a subsequent dismissal even after the charge is no longer pending?
Justice Busby, I think if the legislature wanted to do that, it needed to use much clearer language like what we see in Curry. I think the best way to read 103.001, Justice Busby, is descriptive. It's describing a state of affairs. If it comes to pass that you've got a claimant who has won a dismissal under one of the following conditions, then he can seek compensation. Nothing in describing that state of affairs gives courts the power to do something that they otherwise don't have the power to do. It's a far cry from what
is sub C meaningless then? You would say the court never has jurisdiction to do what the legislature is asking it to do in sub C, right?
Oh, not at all, Justice Busby. Our argument doesn't write out subsection C at all. C is one of the several avenues that an applicant can use to gain relief if he were to meet the conditions set out there. Now, Brown hasn't done that in this case because the order that he's relying on is void for lack of jurisdiction. But if you had an order that were not, then subsection C certainly could be implicated.
But Mr. Hawkins, if in fact the trial court were to dismiss a suit based upon some other ground in actual innocence at that time, such as here, prosecutorial misconduct, and then it's later determined that person who had been incarcerated for all those years was innocent, there would be no way for them to get compensation under the statute, if you're correct. Is that right?
Justice Lehrman, I think the answer to that is probably yes, but I want to include a critical asterisk that I didn't hear Mr. Jefferson address at all. Mr. Jefferson is suggesting that if Mr. Brown doesn't get compensation under the statute, then he's going to be left out in the cold. And I think that that's not true. There are at least 3 avenues by which Mr. Brown could receive compensation outside of the Tim Cole Act. Number 1, he can seek a pardon from the governor based on a finding of actual innocence. If he were to receive that pardon under the Tim Cole Act, that is basis for compensation by itself. Number 2, he can pursue a 1983 action in federal court. And indeed, he is doing that right now, Justice Lehrman. Today, he has an action pending against the city of Houston in the federal district court in the Southern District of Texas. Number 3, he can seek a private bill from the legislature authorizing compensation. The legislature has done that before in the case of Kenneth Massey. If the legislature believes that Brown is the victim of an injustice, it can do the same thing again here.
Mr. Hawkins, requiring Mr. Brown to pursue the pardon or the 1983 or the legislative action, is that different than how the comptroller has treated other similarly situated claimants under the?
It's not, Justice Guzman. Mr. Jefferson alluded to the Overton case and the Rodriguez case. Now, the relevant motions to dismiss in those cases are both in the record, and they differ from what the comptroller was presented with here in a critical respect. These motions to dismiss in Overton and Rodriguez do not highlight the jurisdictional defect because they do not say that the matter had previously been dismissed. This case, of course, is different because here, both the amended motion to dismiss and the court's order itself presented to the comptroller both acknowledge that the case had already been dismissed, which of course put the comptroller on notice that their invalid orders issued without jurisdiction. And that's what we're missing in Overton and Rodriguez. But Justice Guzman, even if I'm wrong about that, even if I'm wrong, the fact that payment was incorrectly made in Overton and Rodriguez is no excuse to get the law wrong in this instance. This court should apply the correct law regardless of any mistake that may have been made in the past as to other claimants.
So just so that I understand, your position is that payment was incorrectly made in those cases, or just on maybe theoretically if it was incorrectly made?
Justice Guzman, I just mean to suggest that if those payments were incorrect, that's not a basis to order the comptroller to pay Brown here and to grant the mandamus relief on an incorrect reading of the Tim Cole Act. I'd like to, if I may, just highlight some of the problems that Mr. Brown's interpretation would lead to if indeed it is the law that the comptroller has to put on blinders and can't look at anything else. Suppose, for example, the order at page 864 had declared explicitly, I lack jurisdiction over this case, but I nevertheless, in the interest of justice, issue an order anyway, declaring Brown actually innocent and dismissing this action. Now, under Brown's theory, the comptroller would have to approve compensation in that instance, but that cannot be consistent with the clearly indicate language the legislature adopted. And as Justice Blacklock indicated earlier, I don't think that's consistent with EH either. Or to provide another example.
How is that? Explain how that's inconsistent with the statute, because it's still on its face under the language of 103. .005, it's still on its face an order dismissing the charge. I mean, even if it's flagrantly invalid, it is nevertheless an order dismissing the charge, which is what the statute tells the comptroller to look for.
Exactly, Justice Blacklock. And that's why I think it's necessary to read the statute as saying a valid order issued by a court of competent jurisdiction. If the statute is not read that way, then the comptroller would have to award relief in that absurd situation. And Justice Blacklock, I'll give you an even more absurd situation. Suppose the comptroller were presented with a court order issued by the 1000th County Court and signed by Judge John Q. Fake Name. Now, everybody knows that there is no 1000th court, and of course, there is no Judge Fake Name. But under Brown's theory, the comptroller would have to accept that and at face value and award compensation anyway.
So there's no difference between an order issued by a pretend court and an order issued by a real court without jurisdiction that isn't appealed?
Well, within the context of the Tim Cole Act, they're effectively the same thing because they are both orders issued without jurisdiction. There's no jurisdiction for either one of them. They're not, I guess, let me back up, Justice Blacklock. I think the better answer is to say they're not valid court orders. The statute must be talking about valid court orders to make any sense.
Well, it's not an order from the state district court in which the charge against the person was pending.
Well, but Justice Busby, we would only know that if we Googled the 1000th court and Judge Fake Name to find out that it was those are made up entities. And Brown says we're not allowed to do that.
Well, you can if that's what the statute says, which is what it says, that it has to be the state district court in which the charge against the person was pending. So I don't see how that's any different from the other section of the statute that says you have to consider whether the determination is based on actual innocence. Whereas here, it doesn't talk about the comptroller looking at whether whether the charge has been previously dismissed or not. There's nothing in the statute about that either way.
So Justice Busby, I don't think the statute speaks to these situations directly at all. I think that when it talks about a court order, it sweeps in all of this by imposing a requirement that it be a valid court order. And that takes care of both of the hypotheticals I presented, and it also takes care of this case where the face of Mr. Brown's application included this obvious defect.
But we still come back to the issue, who determines validity? If the prosecutor thought it was valid and the trial judge thought it was valid, how can the comptroller redetermine validity?
Well, Mr. Chief Justice, I think it's important to take a step back and look at the text of the statute in answering that question. The statute says the documents on their face have to clearly indicate an entitlement to relief. When the face of the documents raise this jurisdictional red flag that puts the comptroller on notice that you've got a potentially void order, then they cannot clearly indicate on their face an entitlement to relief. I think that Mr. Brown is seeking to read the words clearly indicate out of the statute. Mr. Brown's preferred interpretation or preferred reading of the statute would change the word clearly indicate to possibly indicate. But of course, the legislature has rejected that possibility.
So in other trial court orders, there's a presumption that attaches that the trial court had the jurisdiction to consider and resolve the issue presented. And are you saying in the Tim Cole Act that presumption does not attach, and that anyone seeking an order declaring a person to be actually innocent must expressly state in the order for it not to be contested by the comptroller that the judge has jurisdiction, rather than relying on the usual presumption that a district court has that jurisdiction if the district court issues the order?
Well, Justice Bland, I don't think that presumption is ironclad. And indeed, that presumption does exist. And I don't mean to suggest it doesn't exist here, but I still think it would be quite wrong to put on blinders to this obvious jurisdictional defect. For one thing, that would lead to the absurd results that I highlighted earlier. For another thing, I don't think inconsistent with saying that there's a presumption that court orders are valid. But that doesn't mean that they necessarily are valid. It's merely a presumption. And I don't think it's improper for the comptroller to identify that red flag, look at the words clearly indicate in the statute and say, I have a ministerial duty not to grant compensation on this application.
Mr.
Seems
Hawkins.
like Go ahead.
Go ahead, Justice Blacklock.
Well, it seems like this sort of collapses into that same question that arose in EH, which is whether an invalid court order is a court order at all. And I guess your position is that a court order issued without jurisdiction is not a court order. It's akin to Judge Fake Name.
I think within the confines of the Tim Cole Act, I think that's effectively correct, Justice Blacklock. The statute has to be read to say a valid court order. And so if you don't have a valid court order, whether because there's no jurisdiction or because it's an obvious forgery or a fraudulent document, in all of those instances, there's no valid court order. And so there can be no compensation.
If the court order in this case had said, I've determined that, the court determines that it has jurisdiction, would the comptroller still have been entitled to deny compensation?
Justice Bland, I think that's a much more difficult scenario. Mr. Chief Justice, may I finish answering the question? Justice Bland, I think that's a much more difficult scenario to answer because in that case, the giant red flag that the comptroller saw in this application is not presented nearly as clearly. So that's a more difficult case that I don't think the court has to resolve here because it's enough here to look at the record and say on the face of this application, there's a jurisdictional defect and the comptroller had no right to overlook that. Any other questions?
I just have a brief question. I'm sorry, go ahead.
Justice Lerman.
It seems to me that what you just said flies in the face of if it's void, and it just doesn't exist. Because if that's true, then it doesn't matter what anybody says about it, right?
Well, no, Justice Lerman, I think the words clearly indicate are doing some work in that scenario, because in that case, you're much closer to something that clearly indicates an entitlement to relief, whereas here, you're not. On the face of the documents, there's no clear indication of entitlement to relief. Whereas in a case that Justice Bland hypothesized, I think you're much closer to a clear entitlement in that type of hypothetical, which of course is not presented here.
May I ask my question, Chief Justice?
Yes.
All right. Looking at the ministerial duty, though, in N. Ray Woodfill in 2015, we concluded in a PC opinion that the city council with a ministerial duty to act on a referendum petition had no authority to question the validity of the requisite signatures after certification by the city secretary. By analogy, after the judge has signed the order, I think we're moving away from the focus on the comptroller's ministerial duties here. And how is this different from, if you're familiar at this point, if not, a follow-up briefing would be fine.
Sure, Justice Guzman, I'm happy to address that. I think the core part of Henry Woodfill is page 479 of that opinion, where the court noted that the city secretary, this is a quote, never claimed the referendum was plagued by forgery or perjury. What's different here is that the district court itself highlighted its own jurisdictional defect on the face of its order by acknowledging that it had already dismissed the action and then purporting to redismiss that. That's different from Woodfill, where the city council was necessarily looking behind the secretary's determination, despite the lack of any facial invalidity. And that's why I think what we're saying here is entirely consistent with Woodfill and also the Shepard versus Thomas case that Brown cites in that same vein.
Thank you, General Hawkins.
Any other questions? Thank you, General. Mr. Jefferson, I think you have 5 minutes.
Thank you, Your Honor. By that reasoning, in that last question, the comptroller would have the authority to say the U.S. Supreme Court didn't have jurisdiction to issue habeas because in the comptroller's view, the jurisdiction was removed. That cannot be the case. The comptroller keeps going back to, it has to be a valid order, but validity is a substantive inquiry. It is one that is directed to the courts. And it's not what the statute says. The statute doesn't say valid order or correct order. It says verified order. And that comports with the comptroller's purely ministerial role. It's like having a clerk at the courthouse who has to prepare a record. The comptroller's job is to make sure it is an official document. To talk about his example of the 1000th district court, okay, that is something that is never going to happen because a court doesn't just reach out and issue orders. This it derives from the district attorney, the very prosecuting attorney that convicted the person in the first place, coming back to the court with a motion to dismiss that is based on that wrongly incarcerated defendant's actual innocence. That's what drives this process. And it is rare, maybe too rare, given the number of exonerations that have taken place, but it is rare. And when there is a court, the order, the comptroller can easily verify that it is a proper court, just like it can verify when it is looking at verified documents that are sworn to, that the sentence was a certain amount of time that impacts compensation. So the order only needs to state certain things. And if it does, that's the end of the comptroller's inquiry.
Mr. Jefferson, take a hard case. Suppose the DA and the trial judge acted in bad faith and they did not think that the defendant was actually innocent, but they wanted him to get compensated anyway. Is there any way for the state to challenge that?
So the answer, I think, goes back to Allen. I've repeated Allen a number of times. That was a 2012 opinion. And this court, in that case, said, we acknowledge that there are potential problems with the Tim Cole Act, such as compensating someone now who later could be retried and found guilty, that may result in compensating somebody who is actually guilty of the crime. The court said the imperfection of humanity means that the state may make mistakes, but that possibility does not vitiate the government's interests in avoiding injustice. So I think you can spin, some collusion cases where all of that is happening at once. I think it is highly unlikely. These are elected officials, both the district attorney and the court. And no one's going to expose themselves, or at least it should be very rare, to the criminal sanction that would attach to submitting fraudulent documents to the comptroller. I want to step back for a second and just ask the court to remember, this man is innocent, actually innocent. There's no dispute about that. The Tim Cole Act was written for this kind of case, to compensate somebody who almost lost his life. He was on death row waiting an execution date, and he was in jail for 12 years. The legislature wrote compassion into the law, and they wrote it textually. And I've gone through the text that shows why this district court had the jurisdiction to issue the order that it did. And if the court system has failed, the court system, the legislature says, must remedy it. And that's why the section that talks about entitlement talks about the DA, and it talks about the courts, and it says nothing about a cashier in the comptroller. The comptroller is in a separate section that says if these requirements are met, if the boxes are checked, he must, the person is eligible and he must pay. And that's his purely ministerial duty. I don't want to lose that fact. And the Hannah Overton cases and Rodriguez, those were instances in which the comptroller did the right thing. And by the way, both of those orders said amended orders. And so the comptroller knew that there was an initial order and an amended order, and yet he paid compensation. So we ask that the court issue a writ commanding the comptroller to perform his purely ministerial duty in this case. Thank you.
Any other questions? Thank you, Mr. Jefferson. That the case is submitted, and that concludes the arguments we have set for this morning. The clerk will adjourn the court.
Oh, yay, oh, yay, oh, yay. The Honorable, the Supreme Court of Texas now stands adjourned.